Good morning, Mr. Petzlos.
Good morning, Chief Justice. Good morning, Your Honors. May it please the Court. Jerry Petros on behalf of Providence and Worcester Railroad Company. The question raised in this appeal is whether the legislature, when it restricted the exercise of eminent domain authority to new pipelines specified in a notice of intention to construct and greater than 1 mile in length, intended to also include a 77-year-old 120-foot section of a pipeline that has never been specified or contained in a notice of intention.
Mr. Petros, I'm sorry to interrupt you, but could you tell me where I can find a copy of the statute in your, is it in your brief?
I'm not, I think we attached in the appendix, I'm not sure.
Appendix?
It's in the addendum.
The addendum, I'm sorry.
Yeah.
Thank you. And
Oh, yes, okay.
Thank you. And we intend to start there. I mean, obviously, there are 3 issues to look at today, and we contend that the plain language of the statute, the legislative history, and the statutory scheme all demonstrate that the legislature knowingly and intentionally restricted the use of eminent domain power to new pipelines subject to a notice of intent to construct and greater than 1 mile in length.
Just another question. I
Sure.
saw from, it's probably Mobile that's saying this, that when the lease was running out, and there were, that the position of the railroad was, we will not renew this lease. Was that just a negotiate, I mean, was that really their position, or was that just a negotiating position?
No, there were negotiations, and I think that's also on the record. There were negotiations, absolutely. Not with
So
respect
it's
to
a
a
price
lease.
question.
The negotiations with respect to an easement. That's correct,
Yes.
Your Honor.
Okay.
The beginning and often the end point of statutory interpretation is, of course, the language of the statutes themselves. Here, the plain language of the statutes, we believe, authorize the siting board only to exercise eminent domain power with respect to new pipelines subject to an NOI. And we think that's present in 3 different places in the statutes. Let me discuss each one of them. First, the legislature's authorization to use eminent domain power is set forth in Section 69S. And that section permits the board to authorize the use of eminent domain power only, and I quote, with respect to oil pipelines specified and contained in a proposed notice of intent submitted in accordance with Section 69J.
Means
Now,
I, right?
It says I, it means J. I mean,
Whichever.
it's undisputed on this record that there was a change in the statutes and they forgot to transpose that letter. Now, that refers to a notice of intent to construct under 69J. That's a new facility. So the legislature, in the very organic statute that authorizes eminent domain in the first instance, says you only have this authority with respect to pipelines contained in a proposed notice of intent. Not surprising, we're dealing with the siting board. It cites facilities. It deals with new facilities. So it's a very logical restriction on the part of the Assembly. Now, it's important that the board's decision in this case does not deal with this issue. In fact, when it cites this quotation, I think on page 9 or 10, it leaves out the portion I just read about being contained in a notice of intent, and you will not find a discussion by the board saying, well, here's why we didn't have to apply that particular issue.
I take it the board would say that the legislature didn't really mean what it said because they couldn't have thought forward to think about this problem.
I think that's all they could possibly say, Your Honor, because it's clear at least what the legislature said. So they're left with, well, they must not have meant it.
Was any legislation submitted, any bill submitted to get eminent domain power for this specific project?
No, there was not, Your Honor.
Is there legislative history that tells us what they were thinking?
There is, Your Honor, and I will jump to that if I may, and I'll jump to it now, Your Honor. The board essentially goes through the statute and says the statute is plain. Now, Mobile, of course, argues that the statute is ambiguous, and there's a lot of discussion about this except clause, except for rebuilding and relaying pipes. The board has no trouble with that, Your Honor. They dismiss it out of hand and say relaying, rebuilding pipes isn't even jurisdictional. It's on pages 8 and 9 of their decision. So that one's sort of a no-brainer for the board. So what they fall back to are 2 things. First, the legislative history. Now, with respect to the legislative history, and I would submit, Your Honor, we don't need to get there, because when the language of the statutes, 69S and 69G, are so clear, you don't have to get to the history. But I embrace the history, too. Let's look at what they did. The board went through the history and in several pages recited pulled out various aspects of the history, appropriately so. But then they get to the penultimate conclusion with respect to the history. And what do they cite? They cite a statement from the 6th report by the Commission. And that statement says, just briefly, eminent domain power and zoning override are necessary because a pipeline could go through 30 or 40 communities, and it's unlikely that these communities would have contiguous and appropriately zoned areas. Now, what are they talking about? This is what the board relies upon. They're talking about new pipelines. Because when you build a new pipeline and you've got a condemned property through 30 or 40 communities, you better have eminent domain authority because you're never going to talk that many people into giving up their property. It just doesn't happen. So even the legislative history, Your Honor, that the board relies upon supports the position advanced by Providence and Worcester and is entirely consistent with what the legislature said. It said new pipelines. You need eminent domain authority for new pipelines because you've got to go through 100 miles through 30 or 40 communities. There is...
Excuse me.
I'm sorry.
Finish,
I
please.
was going to say there's nothing in the legislative history, Your Honor, which says that gives any suggestion that they intended to include existing pipelines. They talk about new pipelines.
What about the definition of oil facility? Would you explain that?
Yes, please. That goes back to the first point I started with, which is that the statutes here are clear and consistent. We talked briefly about 69S. That authorizes eminent domain in the first instance. We talked about the limitation to notice of intent to construct a new facility. 69S also says, second restriction, this power applies only to facilities that are defined as oil facilities under Section 69G, which takes us to 69G.
You would, and nobody's disagreeing that when it says facilities, it really means oil facilities, not facilities.
We all
correct?
agree on that, yes, Your Honor. Now let's go back to 69G and take a look at what it says. It refers to, once again, new pipelines. Now, I don't think it's a stretch to say that when the legislature said new pipelines, they knew that they were not including existing pipelines. That's not really a hard intellectual concept to wrap your arms around. But there's more. Look at 69G. The very beginning of 69G talks about refineries and storage facilities for oil. Look what it says. Any new unit. There's that language again. Any new unit. And then it says new pipelines.
Well, here's the conundrum that's obvious in the face of the opinion of the board, in that the application of those words is both inconsistent with the purpose of the statute and results in essence, an absurd result here. And that is that, fine, we'll make mobile build a new pipeline under your railroad and grant it eminent domain power in that circumstance. And that is an absurd, uneconomic result, inconsistent with the whole purpose of the Energy Siting Facilities Department, board. And so why can't we take that into account when we apply the statute in these circumstances?
Because, Your Honor, for two reasons. First of all, it is not an absurd result by any means.
But why isn't it an absurd result?
Because what you have here, first of all, is a legislature stating very clearly in two separate sections, 69S and 69G, that they permit this exercise of an extraordinary power, as this Court noted in 2007 in a decision authored by the Chief Justice, that this extraordinary power can be exercised only as specified in 69S and 69G. And if you look at the limitation, Justice Cordy, what does it limit to? It's limited to new facilities. Not just, by the way, oil facilities, but oil storage facilities, electrical transmission facilities, same restriction there, new, and natural gas facilities, new. Now, why does that restriction appear with respect to all of these situations? Because we're dealing with a siting board. And the siting board's basic jurisdiction, as set forth by this Court in the Plymouth County case, is for new facilities. It doesn't apply to old facilities or facilities existing prior to 1976.
So you're saying that if, in fact, Mobile says, okay, we'll build a new section on this 65-mile pipeline under this 2 feet from our current pipeline, siting board has jurisdiction?
Absolutely not, Your Honor. It goes back to the except restructuring and rebuilding. That language is
I'm talking
there.
about building a new section.
I am too, Your
I'm
Honor.
not talking about cleaning.
I'm talking about a new section as well. The except language, it's clear what the except language means. The board says the same thing. It says if what you're doing is simply replacing a section of the pipeline of the same capacity, now that's the key differentiation, of the same capacity, then that's not even jurisdictional to the siting board. The Siting Board reaches that conclusion easily, I think, on page 9 of their own decision. What has to happen for it to be jurisdictional is you have to increase capacity. You have to be building what is essentially a new pipeline. So if you take a 6-inch pipeline and
So
make
you're
it
going to
a
put 8-inch
12-inch.
pipe in. So we'll put 8-inch pipe in this time.
Well, in fact, the board deals with that. There are regulations that talk about increases in capacity with respect to electrical transmission and natural gas.
So you're suggesting
But
the
even if
board's-
you put in, I'm sorry, Your Honor, if you put in an 8-inch pipeline or a 10-inch pipeline or a 12-inch pipeline over this 120-foot section, it doesn't change the capacity of the pipeline. You've still got a 6-inch pipeline for 84 miles on either side of it. So
You're suggesting that Providence and Worcester Railroad can literally strangle Western Massachusetts. And that's okay, and the state is powerless, the Energy Siting Facilities Board, responsible for ensuring that we have a sufficient supply of energy,
He's
is
saying you should talk to
powerless
the
to do anything about this.
I'm suggesting, Your Honor, that the legislature made a very reasonable and logical choice when it allowed the board to use eminent domain power and restricted where they could do that. Legislature could have said, you can do it wherever you find there'll be a substantial impact, or used many other formulations. They
Mr.
didn't do
Pizos,
that. If I could just finish that
Chair.
question. And in this situation, Your Honor, it doesn't strangle Western Massachusetts. There's sparse evidence in the record about what happens, but I can tell you, Your Honor, that the record does demonstrate there are plenty of other suppliers out there, not just Mobil. There are other
Do you
gasoline
have other
companies.
pipelines that go under your railroad, by the way? You
I'm
have other
sorry?
pipelines from other companies for other purposes
We
going
do
under
not.
your railroad?
We do not, just Mobil.
Mr. Pizos,
Although-
let me ask you this. It seems to me that I understand your argument, and certainly the statutory language is helpful to you. It seems to me that when building a pipeline, what the legislature probably had in mind, at least it's a reasonable argument, was that if any owner over or under whose property the pipeline was due to go, refused to give permission to have the pipeline go across the property or under the property, in that case, eminent domain is available. But you have a lot of landowners who may think, gee, I can lease this, get some money from this, right? You are asking us to read the statute to say if a landowner has once given that permission so that in fact the pipeline can across the land, but subsequently either because there's a change of ownership or because they want to increase the amount that they're charging, can sort of opt out of the scheme. Is that consistent with what the legislature was trying to do here?
I believe it is, Your Honor, for these reasons. Again, what the legislature did is fairly clear. But beyond that, you have this...
What the legislature is it seems to me that at minimum what the legislature is trying to do is to say if we're going to have a pipeline from A to B and
Right.
it crosses over private land and somebody says, I'm not going to let you cross over my land, and given that the siting board has made all the requisite findings, the authority of the state can be exercised to compel
Absolutely.
somebody to do that.
Absolutely, yes.
But a lot of owners would, as I said, say, be my guest, pay me some money, and I'll let you cross over.
Absolutely. But in this case, Chief Justice, there were leases signed going back to 1931. Mobil was on that lease for the last 27 years. Mobil put itself in this position. Mobil could have renegotiated a lease 10 years ago, 15 years ago, 5 years ago. It chose instead to wait till the lease expired. As the record indicates, it appraised the lease at a sum of $2,500, which was less than 1 month's
Oh, I
payment.
understand. That's the particularities of this case. But what you're really saying to me is, let's say, you had sold the land, and the next land, even if Mobil started negotiating 10 years ago, just said, we don't want to negotiate. We don't want your pipe here.
But isn't your
That's right.
Isn't your point cutting through? Well, whatever may be the rationale or the reasonableness of such a position, the language of the statute is crystal clear that new means new, and
It
this
is.
isn't new.
It is, and I understand that if the statute at times is so absurd or illogical that the court will look behind it. But in this case, the statute
Well,
is
that's what
very
I'm
reasonable.
trying to, I said at the beginning, the language
Yes.
is very clear, but I'm
Yes.
trying to look at what the purpose was. And it seems to me that essentially what you are saying, and maybe this was consistent with it, and is not an absurd result, that you can build a pipeline from A to B, that you, in essence, either have to take by eminent domain every single piece of land, or proceed at your risk.
That's correct, Your Honor, because the purpose of the statute was to permit new facilities to be constructed, and that's why jurisdictional facilities to be constructed, and that's why that language new appears, again, not just with oil facilities, but with all facilities, electric, natural gas, storage facilities, refining facilities. The legislature made a deliberate, knowing decision here to restrict the exercise of this very high power of government, and under those circumstances, it was a reasonable decision. Was it the only decision? No, they could have made a different decision. I acknowledge that. But it was a reasonable decision. And for that reason, it deserves the respect of the court, I submit.
Could I just ask one question?
Certainly.
I wanted to ask, because there's reference in the record to Rhode Island.
Yes.
What occurred when the Public Utilities Commissioner, whoever in Rhode Island, said, you can't do this by eminent domain? What happened?
The matter was resolved in less than a month. We had exactly the same situation. The pipeline crosses the railroad in two places, one in Rhode Island, one in Massachusetts. The exact same situation happened. We went there in front of the Public Utility Commission. They said they had no jurisdiction. The parties reached an agreement in 1 month.
Thank you,
Thank you,
Mr.
Your Honors.
Petros. Mr. Blake?
Yes, Your Honor, thank you. May it please the court, Stephen Brake for Mobile Pipeline Company.
Mr. Brake, why doesn't the statute mean what it says? I mean, why would they write those words and then have us not apply them? Or why shouldn't the board apply them as written?
Well, Your Honor, I think it does, in a sense, mean what it says. But I would submit to you that
New?
well, you know, Your Honor, what it speaks of new pipelines, and then it goes into this except clause, and clearly.
But why does the except clause modify the word new?
The reason it does, Your Honor, I would submit to you, is that it either has to be read as saying new pipelines are the statute has to be read as saying new pipelines are the only pipelines to be included here. And let us be clear that where you rebuild, reconstruct a pipeline of the same capacity, that's not a new pipeline.
Correct.
You could impose that reading on it if you wished.
And
However,
it's interesting, the original hearing officer, who must, unless this was his or her first case, must have had some experience, and that was the interpretation that he or she applied.
it was, however, an interpretation with which many of the board members, subsequently a majority of the board members, disagreed. And
By rewriting, by saying that the words of the statute don't mean what they say.
I don't think that's, I would submit to you, Your Honor, that's really not quite what they did. What they did is struggle with the statute overall in the context of its directive in, I think it's section H, 69H, where they admonish the board to provide the lowest cost energy to the Commonwealth at the least economic environmental disruption. But at the same time, they then recognized that there are, in fact, a series of absurd results that would come from a highly literalistic reading of that section.
Well,
and on that basis, I acknowledge, did not deal with the section that I urged upon them to consider that the except clause.
Well, they dealt with it. They rejected it.
They rejected my contention,
Yes.
absolutely. However, I would submit to you that the except clause should be read to say, and this is how, having thought about it, the best formulation I have, which I would submit is the most logical reading of what is undeniably a confusing and enigmatic provision. And I think there are several of them throughout
If
this.
you read it, if
I
you
would
read it
choose to
straightforward, it's very clear. It's not ambiguous. It's not.
Well, if I may, Your Honor, let me suggest to you that if a pipeline was replacing, for lack of a better term, an existing pipeline, and it was built, newly built from new pipe, and it was of a different capacity than the one that we're replacing, that plainly, by any conception, is a new pipeline. It is of a different.
Would that new pipeline require the Comprehensive Siting Board to review for determinations of need, environmental impacts, and routing?
I would submit to you that it plainly would, Your
Okay,
Honor,
because
yes.
that's new. But then what about this one? If we adopt your position, would that mean that every time an operator of an oil facility or an electric or a gas facility needed a necessary repair to a facility, adopting your reading, wouldn't that repair then require the Comprehensive Siting Board review and the adjudication of need, environmental impacts?
No, Your Honor, it wouldn't. I think that's exactly, and the use of the phrase that you've picked up on, necessary repair, that I would submit to you plainly would not. But if you do replace the entire pipeline of the same capacity, that exception is actually an exception to the universe of excluded, non-new existing pipelines. And if I could submit to you that we're focusing on the definition of oil facility in 69G, I think it is, the definitional sections of the statute. There's another definition in there. Mr. Petros alluded to the fact that we have separate provisions for natural gas facilities and whatnot. That's the definition of the term facility by itself. And those two definitions are analogous in certain respects. And for our purposes, they are directly the same in the one important respect, which is that this definition of facility applying to natural gas and LNG facilities has exactly the same language in it, where it refers to a new facility of such and such PSI, and but it excludes, has the same exception that we're talking about here, with the restructuring, rebuilding, and such. And what the board did is issued regulations excluding from its ambit, and these are cited in our brief, but they're, for clarity's sake, it's 980 CMR 7.07, and then the exclusions are parentheses 8. And what the board does is it promulgated a series of circumstances that did not constitute the construction of facilities, the other definition, not oil facilities, but identical language, that do not constitute the construction of facilities. And in it, it excludes from its ambit the necessary maintenance of existing facilities for the storage of gas or existing pipelines, the upgrading of a pipeline, as long as it's been around for 24 months and is capable of operating at certain pressures, and the construction of a pipeline which for 2 years of service was used at a pressure and such, and then it explicitly invokes the language, involves the rebuilding, relaying, minor relocation or restructuring of all or part of an existing line, which traverses essentially the same route. Now, they've excluded expressly in their regulations the kind of situation we have here. I would submit to you that the only reason...
But they don't have regulations for oil facilities.
They do not. That is correct, Your Honor. However, the language is identical. And my point here would be that what, in essence, they're doing is they are saying that it is within the statute. There would be absolutely no reason for these regulations to exclude specifically from the statutory ambit this particular type of work on facilities of an identical nature, this is a new natural gas pipeline. They're excluding it for the simple reason that my reading of the except clause, I would submit to you, is correct. It is not a new pipeline to rebuild and reconstruct it, but it is included within the ambit. If you reconstruct a 100-mile pipeline...
Have any other statute where accept is used to mean not accept?
Well, you know, Your Honor, I'm not really saying that it's not accept. They say new pipelines are included in the first sentence. By definition, that excludes, I would submit to you, all existing pipelines. And so the exception, I would submit to you, is not elegantly drafted, but is an exclusion from that universe of existing pipelines. And that has to be, I would submit to you, the construction adopted by the board itself when it promulgated certain specific exclusions here. Be that as it may, Your Honor, the fact of the matter is, and why I submit the board made a reasonable construction of the statute in going forward as it did, it is the case, even if we go and read the statute, if you were to read the statute as adopted by Providence and Worcester Railroad, and come in and say, basically, essentially this, that you have to reconstruct, or you have to build a new pipeline of a different capacity of greater than 1 mile in length. The most that would require of us here, I would submit to you, is that the length be greater than a mile, that it encompass this 120-foot rail bed, and that it basically be of a different capacity, 8 inches instead of 6 inches, with valves in a different way to allow in the aggregate some additional amount of gasoline to move through to Springfield. And I would submit to you that the board had this one correct, that the literal reading of this statute intended to preserve for the Commonwealth the maximally efficient energy infrastructure, to require that process to occur, to artificially rebuild that portion at a different capacity in order to be able to obtain eminent domain power of a 120-foot segment between here and Springfield, between Providence and Springfield.
Isn't your real remedy with the legislature?
Well, they could make life easy for everyone if they were to do that. That's to be sure. But the reality is that this statute, I would submit, Your Honor, is absolutely replete with, as it looks through its various cross-references, there are at least 3 I noted that, in a sense, directly pertain to us. And if you were to literally apply this statute through all of its myriad of sections, you will end up with a number of extremely absurd results.
I just don't know how you avoid dealing with the word new as it appears all the way through, dealing with the word accept? I don't know.
I think, Your Honor, in the regulations, what they're recognizing, the board itself is recognizing, and what they recognized in our decision is that basically the statute has to consider what happens when major infrastructure is rebuilt or dealt with. It
Maybe you
isn't
have to
simply
pay a little more
excluded.
rent. And since you had the
Well, you know,
largest
Your Honor-
profit in your entire history,
You-
I
you
think
know,
you
Your Honor-
probably could.
You know, Your Honor, I don't think it's really quite as simple as it was intimated to you. And then the record is not terribly replete, although most of it, the summary judgment papers for the injunction papers before the Superior Court are there. And the fact of the matter is that these two parties had dealings in Rhode Island where there was no statute whatsoever. And an
Dealings
economic...
in what? In what? I didn't.
Rhode Island.
In Rhode
Rhode
Island.
Island.
And it was sort of Act One. And at that time, there was no statute whatsoever. So basically, it got resolved on, shall we style it, an economic basis. And I understand that this looks like quite simply a mere economic dispute in that sense of the word. But the reality is, whatever negotiations took place, there's precious little here because there's precious little to put there. The reality is that the economic consequences, and they are listed in the injunction papers, are very considerable. Obviously for ExxonMobil, but it's a private entity, and as we all know, a very large economic entity. But just the same, there are further consequences to it, but there's a very considerable economic cost. And the reality is that no one is coming before this court and asking it to authorize an eminent domain process that would result in anything less than the full fair market value of this easement to Providence and Worcester Railroad.
Mr. Blake, may I ask you this? Does the record reflect of the pipeline at issue here, how much of the, over how many privately held properties it passes, and of those, how many were taken by eminent domain?
It does not, Your Honor, and I do not know the answer to that.
Mr. Brake, if I boil down your argument, am I right in saying that your position is that to interpret the plain language the way it reads would result in an absurd result?
That is correct.
That's
I am
what it
asserting
boils
that, Your
down
Honor.
to. So you concede that the plain language is against you, but you're saying that the result is absurd, and therefore a more reasonable interpretation would be to be consistent with the language in 69H, which talks about a minimum impact on the environment at the lowest possible cost. That's your argument, isn't it?
It is largely, Your Honor. When you say that I concede the first point that the language is against
Sounds
me,
like it.
what I would call to Your Honor's attention is that I think that the statute, in the accept phrase, struggles with what to do about a major rebuilding of infrastructure. And the board themselves in the regulations, albeit for natural gas facilities, the board itself struggles with when it's to assert jurisdiction, so to speak, over a major rebuilding. So,
Mr. Blake,
yes, Your
excuse me, are you finished your answer?
Yes.
Mr. Blake, you heard me ask Mr. Pietzlos the question. Essentially, as I take it, his client's position is as follows. At the inception, when this pipeline was being built by Mobile Pipeline or its predecessor, it had the option of attempting to take by eminent domain all of the land. And if it didn't, it proceeded at its own risk. The difficulty, first of all, I'd like you to comment on that, but keep in mind the language of Section 69S that says if such company is unable to reach agreement, right? He seems to say, well, you have the option of eminent domain and otherwise you proceed at your risk. And what I see is you don't get to exercise this power of government unless you are unable to reach an agreement, correct?
yes, I think that is correct, Your Honor. I think, however, the context is the pipeline, the record reflects, was built in 1931.
Right.
And
Long before the statute.
I believe, the statute was passed in the 1970s in a series of tranches, it almost seems, in response to the various energy crises at that time. I don't believe that there would have been any right for a pipeline company, an oil company, to purchase, to use eminent domain to establish its right in 1931.
But even if I'm talking about a new pipeline today, right?
I see. Well, with respect to a new pipeline today, I think it is the case that obviously the language of the statute imposes, as it were, a burden to approach the private landowner and to seek to reach agreement. I would submit to you that that manifestly has occurred here. And in fact, what is so enticing about this is because the economic costs are grave to closing the Springfield terminal, and never mind, we've argued public interest aspects as well, since other suppliers do use this terminal, the only one in Western Massachusetts. But putting that aside, because the economic consequences are grave, that there is, to be perfectly honest, a premium to be extracted in this particular circumstance, above and beyond what an easement would otherwise cost. It's sort of the last man in phenomena. I would submit to you that this is precisely the kind of situation that the eminent domain right was intended to prevent. That one need not, how much of an effort need one make to reach agreement with the particular landowner? Because an agreement
Well,
was certainly
I'm
sought
trying to
here.
simply understand the statute, even if we were writing on a clean slate. So it seems to me that you're building a new pipeline. You first have to go to the landowner. The landowner says, yes, I'll license you. That land is then sold, right?
Cool.
And the next landowner, when the lease is up, doesn't want, doesn't want the pipe there. Doesn't believe in whatever's going through the pipe, natural gas or whatever it is, and just says no.
And of course, the incentive, as the various landowners, the 30 to 40 communities referenced in the legislative history, as the various landowners reach agreement, as it were, then surely the remaining landowner sits in an ever greater position to extract a premium absent the power of eminent domain, which I would submit to you is, by historical accident, what has occurred in this circumstance. And I would call Your Honor's attention to the fact, in closing, that this statute does have throughout it a number of circumstances under which it plainly is drafted in ways that would lead to absurd results. And here, quite frankly, if the power of eminent domain does not reach this limited circumstance with respect to existing pipelines, one such result will obtain.
Thank you, Mr. Blake.